this should really give everyone a well-rounded foundation about estate planning and what's important and what you need to have. Okay, so when you die, there are four ways that assets pass when you die. So one is, and we'll go over it, joint ownership. So let's say a husband and wife, they have a joint bank account, okay, and that is with both of their names on it, and that's usually called a joint bank account with rights of survivorship or tenants by the entirety. So in that case, when one of the account owners dies, the bank account or the brokerage account or the home automatically, by operation of law, passes to the survivor. So when two names are on a bank account or two names are on the deed to your home, okay, and they're titled between a husband and wife, for example, it doesn't pass by a will, or the disposition of the house doesn't need to go through the probate process. The asset just automatically becomes the sole asset of the survivor, of whoever's on the account or whoever's on the deed. Okay. In particular, when husbands and wives have accounts that are titled jointly between them, that type of titling, which is called tenants by the entirety, and you can title bank accounts that way or your home that way, not only does it avoid the probate process, but those assets, whether they're accounts or the home, offer heightened creditor protection. So for example, let's say my wife and I own our home as tenants by the entirety, and I get into a car accident and I kill somebody, and I'm sued personally. Our home is protected because it is titled jointly between a husband and wife, and my creditors can't get to that asset. So it's very important when you have a husband and wife and a married couple, it's important to the extent you can to make sure that your assets, your bank accounts, your brokerage accounts, your home are titled as tenants by the entirety to get that extra creditor protection. That same protection doesn't exist if I was on a joint account with my mother, for instance. If I was on a joint bank account with my mother, and again, I caused an accident, my creditors could get to that account. So it's only between a husband and wife. Okay. One of the problems that I see when I meet with clients is, let's say there's an elderly parent, and what they want is the parent really can't handle their financial affairs. So what they do is they might name like the oldest son or the oldest daughter and they add them to the account so that they can write checks for them and handle their banking. So the potential problem with this is that if the son or the daughter who is handling the banking for the parent, if they get into an accident or they get divorced or they have creditor problems, it's possible that the money in that account could end up going to the creditors, even though most of it was parents' money. So it's important to be very careful about that. There are other things that can be done to allow somebody to act on behalf of their parents and do their parents' banking without subjecting the accounts to risk. And we'll talk about that later on in the presentation. Okay. Another way that assets pass when people die is by contract. So at BICO, for example, you might have a 401k or a retirement account or a life insurance policy. And when you signed up and you got access to those types of assets, you filled out a beneficiary designation form. And so on the form, you get to write down who the primary beneficiary is and the contingent beneficiary. So when you die, for example, a retirement account, I wrote down that it goes to my wife, and if she predeceases me, then it goes to my kids. So those types of accounts, they don't pass pursuant to a will. They are with the beneficiary designation form. Okay. One of the problems that I see is, let's say people will come in to see me and they have updated their wills, or I will help update their wills for them. But it's important to also update the, your retirement account beneficiary designations or your life insurance designations. For example, if you're married and then you get divorced and you change your will so that your ex-spouse is no longer a beneficiary and everything now goes to your kids, if you don't update and change your beneficiary forms on your life insurance and retirement accounts, and you previously designated your spouse as the primary beneficiary, then if something happens to you, they're still the primary beneficiary. So it's important to make sure those are updated as well. Okay. Finally, or not finally, what happens if you don't have a will? And so if I have, let's say, a bank account or a brokerage account in my name, I'm not married, so it's not a joint account, it's in my name alone, and it doesn't have a beneficiary designation, and I die. So what happens to my home, my bank accounts, my brokerage accounts if I don't have a will? Well, I actually do have a will, and it's called an intestacy statute, and every state has one. And what happens is the state of Maryland or DC or Virginia, they have a will that's created for me. And it says what happens to my assets when I die if I don't have a will. And so generally, for a single unmarried person, if I wasn't married, whatever I had would go in equal shares to my children. Okay. If I didn't have any children and I died, then whatever I had would go in equal shares to my parents. And if they weren't living, then it would go to my siblings. If I didn't have siblings, then it would go to, the closest living relatives. So let's say cousins, aunts, uncles, nieces, and nephews. Does anyone have any questions so far? I've kind of moved along pretty quickly. Caitlin? Any? No questions?
No, we're all good.
All right. If I am married and I don't have a will, what happens? Well, people might think that, oh, everything will go, if I died and I didn't have a will, everything in my name would go to my wife. That is not the case in Maryland, and it's not the case in DC or Virginia or in most states. If I'm married and I have kids, only half, at least in Maryland, would end up going to my wife, and the other half would end up going to my children. And so it would be in, let's say, a custodial account until they're 18. And once they're 18, they would get it. Well, most people, husbands and wives that I work with, the husbands and wives, they want everything to go to each other. And then only at the second death do they want the assets to go to their children. So again, one of the important reasons to have a will is to make sure that the assets go where you want. And so you want to avoid that potential problem. So when you don't have a will, the biggest thing is you really are giving up control. You don't have the ability to say where your assets go. If you're married, your spouse may end up not being the beneficiary of all the assets. Another potential problem is that, let's say, a husband and wife, they die and everything goes to their children. Their children would likely get access to everything when they're 18. Well, that's young. Most of my clients would like to plan, and maybe they would set up a trust for their kids so that they might not get access to the money till they're, let's say, 25 or 30 or 35. And I'll talk about trusts a little bit later and how they work. But if you don't have a will and you don't plan, you give up those options. Okay. In the will is also where you designate the guardians for your children. If you don't lay it out as to who you want to be the guardians for your children, then the courts will decide, and that's when there could potentially be a fight. One sibling may want to have, be guardian or a parent, and they're, and I see this all the time where I meet with clients and I say, all right, well, who would you like to name as the guardian? And the wife will say, oh, I want my brother. And the husband will say, what, your brother should, he's irresponsible. I want my, it should be my sister. So it's important that you come together, you think about it, you plan, and you are proactive and you choose, for in this case the guardian, that so that it's not left up in the air to the courts. Okay. Another reason for either for planning and having a will is, if it's applicable, you can take steps to minimize estate taxes or minimize taxes. And finally, creditor protection. And I'm going to talk a little bit more about this later, but with proper planning, there's a way for people to leave their money to their children and descendants in a way so that that money is protected in the event they get divorced or they get sued. And if they just get their money outright, then they're giving up those protections. Okay. Caitlin, any questions? Nope. All right. Chime in when you get some.
Sure.
All right. Oh, Will.
Oh, actually, I'm so sorry. One just popped in the chat right now.
Good. All right.
To your first point, you said if we get into an accident and have to file for bankruptcy, they can come after our spouse. They just said they've been in that situation and their assets were protected if everything was in a joint account.
They're making a comment or a question?
It seems like more of a comment, I suppose.
Okay. Well, again, I'm not really dealing with bankruptcy, but generally speaking, if a husband and wife have their assets jointly titled, they are in a better position, and the chances of having their assets better protected are better if they are titled jointly between them than if they are titled separately.
So having a joint account is a good way to protect our assets when you are married.
Correct.
Right.
Who can make a will? So I've talked about why it's important to have one for all the reasons so that you can have control. Well, let me tell you what's required. One, you got to be an adult. You have to be over 18 years of age. Okay. It has to be in writing. And a very important point is it's got to be witnessed. So 2 witnesses have to sign the will, and you have to sign it in front of them. So when I'm signing my will, I have to do it in front of the 2 witnesses who are standing in the room with me while I'm signing the will. Okay. When people try and do this on their own or they don't know the rules, they may have a very detailed list. And I've had clients where this has been an issue, where somebody dies and then they had a nice will and it was dated and they wrote everything out as to where they wanted their assets to go. And they were very specific, but they didn't have witnesses. And if you don't have 2 witnesses in Maryland, it's not valid. You might as well have had nothing. And so if you're going to have a will, it's got to be done properly. Another problem I see is people will have a will, and then whether they did it on their own or they went to a lawyer, and then later on they decide, oh, I want to make a change to it. So they take the will out and they cross something, they cross out a name, or they'll write in another name. Well, that's when you get into trouble. When you start doing that, if that's not done in a proper way and there are witnesses to that crossing it out and everyone re-signs, then those changes may not be valid. So I have to say, if you're going to do a will and you're going to have changes to it, it's best to see a lawyer and get do a new one or do a codicil and make sure that the changes are done properly, so that you don't run into your heirs when you die are not left fighting and disputing your will or your codicil, and your wishes aren't followed. Okay.
We do have a couple of questions.
Okay, good.
Slide. Do witnesses have to be adults?
Yes, the witnesses also have to be adults.
Okay. Do you have to ask specifically for the tenants by entirety title when you are jointly on mortgage or bank accounts?
Yes, you should specifically ask for that. Now, if it's a husband and wife and it's titled that way, it says husband and wife, it will likely get that protection. But it's important when you go to the bank or you have a brokerage account, you want to make sure that it's tenants by the entirety, or you're both designated as husband and wife on the account. And yes, it's important to have it designated that way.
Okay. And finally, do wills have to be registered in these jurisdictions?
Yeah, so that's a very good question. They don't. You can, so some places like Montgomery County, the Register of Wills, you can file your will and they will keep it for safekeeping. Our clients, we keep them. We give our clients copies of everything. We have a secure offsite facility, and after we scan everything in, we keep it there so that clients don't lose them. But but they're not required to be filed, so you don't have to do that. It's important because you don't want to lose your will, and if you lose your will, while a copy can be admitted, it's a pain. Sometimes you have to have people go to court and you have to dig up the witnesses, and it could be a potential problem. So it's important that you have the original, and if filing it with the local county registrar's office if that's the best way, then I think that may be something good to do.
Okay. And finally, if you want to create a brand new will, how do you cancel or void an existing one?
Yeah, so you don't specifically have to. So the latest dated will automatically supersede the previous one. But it's a good idea if you do a new will, I would rip up and destroy the old one. But the latest will that's witnessed and that's properly witnessed and dated, that will be the current legally valid will.
Okay, perfect. And I have one more that just came through.
Okay.
Would there be any reason to not file your will with the registrar's office?
Well, I'd say a lot of attorneys will like I said, we keep the originals. We don't charge anything. I think if you have an attorney and they offer to do that and they're not charging, I would probably do that. If you keep it in a safe place and you're not, let's say it's in a safe deposit box and you don't think you're prone to losing things, you could do that. A lot of my clients, or well, not my clients, but I think a lot of people do that. But there's certainly nothing wrong with filing it with the register. It's probably not a bad idea.
Okay, I'll let you proceed on to your next slide.
Okay. Probate. So people always hear about probate and it's terrible. I need to avoid probate. Well, let me explain what it is. Probate is the process that when somebody dies, you got to get all the assets out of the person's name when they die to their beneficiaries. So, for example, suppose my mother dies and in her will, she leaves everything to me. I'm an only child. She has a home, she has a bank account, she has a brokerage account, and only her name is on that. And we have to get in her will, she names me as I'm the sole beneficiary, and she names me as the personal representative of her estate, which is also like the guardian. It's the same. A personal representative, not a guardian, and an executor are the same thing. So probate is, so suppose she dies and I go to Bank of America where she has a bank account, and I take her death certificate and I take her will to the teller at Bank of America, and I say, oh, my mother died, here's her death certificate, and here's her will, and in the will it says that I'm the personal representative and I'm the beneficiary. So clerk, would you please close her account and then give me a check? And the clerk is going to tell me to take a hike because only my mother has legal authority over her bank accounts and her brokerage accounts. I'm not on the account. So the way that I can get access to the account as the personal representative is the probate process. So I file the death certificate and the will with the Register of Wills in Montgomery County, that's the probate court, and they will officially appoint me as the personal representative of her estate. And they send me something what's called letters of administration. And it's a one-page document. It has a raised seal, and it says that Todd Bornstein is the personal representative of her estate. And with that document, I now have legal access to all my mother's accounts that she had. So if I take that letters of administration to Bank of America or to Charles Schwab or wherever she had accounts, I can then close the accounts, and then as part of the process of the probate process is winding up her affairs. So I will pay her final credit card bills and her funeral bills. I'll have to file her final income tax return, pay, like I said, pay her creditors. So once I do all of those things, then I've taken care of everything that she owes. Then I can close her estate and distribute whatever's left to me as the beneficiary. So part of the probate process, again, is not only getting access to the assets, but what I will do is I will have to file a report with the probate court listing all of my mother's accounts. So I'll list the bank account, the brokerage account, I'll list her home, and I'll have to get an appraisal of the home and report the fair market value of the home and all her accounts. And I have to report that to the probate court because they need an accounting of everything that was in her estate. And then on the accounting that I file, so I list all those assets, then I will list all the expenses that I paid that were paid from her estate. So I'll show taxes that were paid, the appraisers that were paid, the legal fees if there were any. I will the credit card bills that were paid. So I'll show all that on an account. I'll show the final number that's left after I paid all the expenses, and then I'll show it getting paid to me as the beneficiary. So that's the probate process. It's getting everything out of somebody's name, filing, tax returns and paying final bills, reporting all of that activity to the probate court, and then distributing everything out to the beneficiaries. That process likely takes about a year to do. So people, why don't they like probate? Well, it takes a little time. So to the extent, for example, if there was a joint account with my mother, and I explained that there may be some issues with that, but the account would automatically come to me. I wouldn't have to go through the probate process. On the next slide, I'll talk about things that we can do to avoid it. But another thing is lack of privacy. Like I said, as part of the process, I have to file an inventory and an accounting with the probate court that lists all of my mother's assets. I have to file the will. It will show who the beneficiaries are. Well, all that's public information. And people, they don't want people to know what they had, what their assets were and who's it going to. And so when you have probate, all of that is public knowledge. So what can you do to avoid that process if you want to? Well, one, we talked about you have assets, particularly husbands and wives, to the extent you can title accounts jointly with rights of survivorship. That's one way. We talked about assets with like 401ks and IRAs and life insurance. If you designate somebody, if my mom had a life insurance policy and she designates me as the beneficiary of that, I just claim the insurance death benefit as a beneficiary. I don't have to file anything with the probate court. Okay. There are also accounts at either banks or brokerage accounts called either payable on death, called POD accounts, or TOD, transfer on death accounts. And those act very similar to a 401k or a life insurance. So even though my mother may have a checking account that ordinarily would have to be reported on the probate process to get it out of her name to me, if it is a payable on death checking account or a payable on death savings account, she can just write my name in as the beneficiary, and then upon her death, it automatically comes to me. Another way to avoid probate is a revocable living trust. And if we have time at the end, I will explain how those work and how those can be used to avoid the probate process. Okay. Let me talk about some common problems or issues that people ask me. What if I do a will and I sign a will, and let's say, and I'm not married, and I leave everything to my siblings or to my parents, and then after I sign the will, I get married? Okay, do I need to do a new will? Well, the answer is yes. After I marry, I want everything to go to my wife, I have to change my will and name my wife as the beneficiary. If not, when I die, whatever's in my name is going to go to my siblings or my parents or whoever was in the will. Okay. What happens if I have a will and I get divorced? Well, it's a good idea. If you get divorced, you should update your will and make sure that you have taken out your ex spouse as a beneficiary. But if you didn't do that, for purposes of your will, your spouse will no longer be a beneficiary. Your spouse will be deemed to have predeceased you. And so whatever was left to your spouse in your will instead go to the contingent beneficiaries. Okay, that works with a will, but that does not work with your life insurance policies or your retirement accounts or your revocable trusts. So with those accounts and a revocable trust, you have to update them, because if you've left your spouse as a beneficiary, they will continue to be a beneficiary. Okay. A question is, well, can I disinherit my spouse? Well, let me explain how this comes up, because it's not quite as bad as it sounds. This comes up in blended families. So suppose, I got married later in life, and so I have 3 kids from a prior marriage, and my wife, she has 2 kids from a prior marriage, and we have our own money, and our deal is that when I die, I'm going to leave everything that I have to my kids, and when she dies, she's going to leave everything she has to her kids. And that's what we've come up with, and that works for us. So sure enough, I die, and my will says, all right, I leave everything to my kids. Well, even though that was what we had agreed to, my wife doesn't have to go along with that. She has a right to a third of all my assets, probate assets, life insurance, retirement accounts, a third of everything, even though I've designated my children as the beneficiaries under my will, as the beneficiaries of the life insurance and retirement accounts. That's called an elective share. So husbands and wives always have this right to a certain percentage, usually a third, to their spouse's estates. Okay, with blended families, they can deal with that through, they can have a prenuptial agreement or a postnuptial agreement, or that's just something that they have to think about and consider. So that's what happens. That's how that comes up. Children. With blended families, there are stepchildren. So who are children for purposes when I say in my will, I leave everything to my children? Well, children are natural born children or legally adopted children, but do not include stepchildren. And so unless you expressly state that in your will that you would like stepchildren to be included, then they would not be included. So people who try and do wills, and they might use LegalZoom or do these documents on their own, there are pitfalls. If you don't do it properly, then assets may not go to where you want them to go. Okay. What happens if I did a will last year and all of a sudden and then we have a new child this year? Do I have to redo the will? Well, usually if the will was written properly, you don't have to. The will will automatically include, so if we say at the death of the survivor of me and my wife, everything will be divided equally between our 3 kids, and I have another child after that, then if the will is written properly, everything will be divided 4 ways. Okay. What happens if, so mom and dad, my parents, they have wills, and I have 3 siblings, and suppose one of my brothers dies before, let's say my mother's a survivor, before my mother dies. And in my mom's will, it says it's going to go equally to me and my 2 siblings. Well, what happens if my brother dies? Where does his share go? Well, it depends on how the will is drafted. One possibility is that if my brother has kids, his share will go in equal shares to his kids. Okay, so if my brother had 2 kids, his 1/3 share would be divided equally to each of his 2 kids. Okay, that's one possibility. Another possibility is it would go only to the 2 surviving children. Okay, another possibility is that his 1/3 would go to his estate and go through whatever he had, whether he had a will or probate estate. So again, this is a common problem. I see this not only in wills, but in beneficiary designation forms. So people might name their 3 children as beneficiaries of life insurance, as contingent beneficiaries. And they put each children down 33%, 33%, 33%. Well, if one of them dies, unless you are specific as to where that one child's 1/3 goes, it may not go to where you want. So it's important to be cognizant about that. Okay. One of the first of all, I went through a lot. Any questions?
So we do have quite a few questions.
Okay.
One of them is many people don't talk about the will after they create it. If I'm to suddenly pass away and I'm unmarried, how would loved ones find out what I've done with my will if it's not filed?
Yes, great idea. So that would be one reason. If you file it and people don't know where a will, the first thing you do is you call up the Montgomery County Register of Wills and you ask them, did somebody file it? Okay, so that would be a good reason to file it. 2, if not, if you should tell somebody, I would tell your family, oh, I did a will. And so a lot of my clients will say, I did a will with Todd Bornstein, and they'll give them copies of the will. They'll give them my business card. And so the family knows that a will was done. They may have copies of it. They have my business card. So communicate. Tell them, oh, I have my will in my safe deposit box, or I have a copy of the will, or the will is in my top dresser drawer. So communicate.
Okay, we have another question. If you set up a power of attorney prior to your death,
Yes.
does the state have to appoint someone as the personal representative, or will the power of attorney cover that?
Okay, so I'm going to talk about powers of attorney right now, and then we'll come back to the question. So this slide is a durable financial power of attorney. This is another important document that everyone should have. Okay, what this document says is if I become, let's say my mother, if my mother becomes mentally incapacitated, she's 80 years old, she has Alzheimer's, and she mentally can't handle her her financial affairs, or she physically can't handle her financial affairs because she can't get out of the house, she can't go to the bank, and she doesn't have online accounts. So a durable financial power of attorney is a document that my mother signs, and she appoints me as her attorney in fact. And that document gives me, when I take that document to the bank, it gives me legal authority to handle her financial affairs. I can do her banking, I could buy and sell her home. Really, a broad, durable power of attorney says that really anything that my mother could do financially, I can do in her place. Okay. This is valid as long as my mother is living. Now, when my mother dies, that power of attorney becomes void. It is only valid during my mother's lifetime. So that power stops. And then, in order for me to get control over her bank accounts and brokerage accounts, is I have to go through the probate process. So the power of attorney is only while somebody is alive. Okay. If my mother didn't have a power of attorney and she became incapacitated, in order for me, and her mortgage needs to be paid, her bills need to be paid, in order for me to access her bank accounts to get these bills paid, is I'd have to file to become her guardian. And that's a legal process. It could be $4,000 or $5,000 for me to go to the court, apply to become a guardian. A lawyer will be appointed for her, and that could take time, and it's a process. So a financial power of attorney is an important document that everyone should have. So husbands and wives usually name each other as a backup. People might name their parents, or if they have adult children, they'll name them. Okay. Another really important document is an advance medical directive. Okay. And this one document, the advance medical directive, does two things. So one part is it's the living will. And a living will says that if, let's say, I'm in a car accident and I'm in a coma, I can say, all right, I want them to pull the plug, or I want them to keep me alive on a respirator or a feeding tube. Sorry if you hear all these ambulances behind me. So the living will is where you can choose the level of care you want if you're brain dead or you're in a coma. Okay. The second part of an advanced medical directive is an appointment of healthcare agent. So that's where, if let's say I can't communicate. I'm in an accident and I can't communicate what I want. I'm not going to die, but I just am unable to communicate with the doctors. I will appoint my wife to make medical decisions on my behalf if I'm unable to. Or if my wife's unable to, then I might name my adult children as my healthcare agents. So this is an important document. If you want to have say as to what's going to happen to you in the event, or even with COVID, for instance, some people may want, intubation or to be put on a respirator, and others may not. So this is a document that all of my clients have.
We have a question as it pertains to that. So it sounds to me like spouses are not automatically, they don't automatically have power of attorney for each other.
So certainly not with respect to financial. Now, realistically, okay, if something happens and there's an accident and you're taken to the hospital, yeah, an emergency room or the doctor are not going to say, oh, well, we're not going to listen to what you want. We're going to have to go to court and get you appointed as a guardian. That's not going to happen. They will listen to you. But what if I'm not married and I have two adult kids, and the two kids come in and they're like, all right, what are we going to do? Procedure A has these certain risks and procedure B has these certain risks. And both of my children come in and they disagree. Well, that could be a potential problem. If I had designated who I wanted to make the decisions for me, that would alleviate that problem. So, any other questions?
Yes, we do have a couple more questions.
So I want to make sure I want 5 minutes to talk about trust because it's very important. So should we answer some questions and then go back?
If you'd like, how about we continue with the trust and we'll finish the rest of the questions at the end.
Okay, all right, because the trust is important.
Perfect.
All right, so you hear about trusts all the time. Well, what are trusts? Why are they created? All right, so People create trust for three main reasons. One is asset management, somebody to manage the trust funds. Two, people create trust to provide creditor protection or divorce protection for the people that they would leaving money for. And three, to save estate taxes. All right, let me give an example of how a trust works, why they would be created. So father, Joe Smith, he died 10 years ago. He left all his assets to his wife, to mom, Sally Smith. And there are two kids. There's Adam and Brian, and mom dies. She died last year, and she had $1 million. And the house was worth 500,000. She had a $250,000 life insurance policy, and bank and brokerage accounts worth 250. So total $1 million. So everything was liquidated, and in her will, she disposes of the $1 million, and $500,000 she leaves to her son Adam outright. No trust, she just leaves it to Adam, free of any trust. The other $500,000 for Brian, her son Brian, she doesn't leave it to him outright. Instead, she leaves it to a trust for Brian's benefit. Okay. And this is logistically how that works. The mom leaves it in a trust, and it's called the Brian Smith Trust. And there are three parties to every trust. There's the grantor, who's the creator of the trust, the person whose money funded the trust. So in this case, it was mom. She's the one, her $500,000 when she died, she was the creator of the trust. Okay. There's the beneficiary, it's Brian and Brian's kids, and there's the trustee. And in this case, the mom named me as the trustee, and my job is to manage the trust. Okay. So the trust says in the mother's will, it actually lays out the provisions of the trust. So in mom's will, it says, I leave $500,000 to a trust for my son Brian, and it's called the Brian Smith Trust. And I appoint Todd Bornstein as the trustee. And during Brian's lifetime, the trustee can make distributions of the principal or the income from the trust to Brian or any of Brian's kids. And then when Brian dies, whatever's left in the trust is going to go in equal shares to Brian's kids. Those provisions are in the mom's will. They're actually spelled out. And so the trust gets created upon mom's death. Okay. So I'm the trustee. I have the $500,000. And what I do is I open up a brokerage account at Charles Schwab. And it says, the account statement says, Brian Smith Trust, Todd Bornstein trustee. I, as the trustee, I have legal authority over the account. I make the investment decisions. I decide when wires can be made to Brian, or I can write checks to Brian. Okay. Brian is the beneficiary. He has no control. He can't call up Schwab and say, oh, I need money. Will you send me money? Brian is not a legal signatory on the account. Only me, the trustee. Okay. Also, I can't use the money for me. Okay. Just because I'm the trustee and I'm on the account, I can only use it for Brian and Brian's kids. I'm not allowed to use the money for myself. Okay. So the trust, so not only can I have the money in a brokerage account, but as the trustee, I could take that money and I could buy a house. And the house will be in the name of the trust, and Brian can live in the trust. I can use that money. A trust can basically own anything that you and I could own. So it could own bank accounts or brokerage accounts or a vacation home, or it could own an interest. It could own stock. It could own an interest in a small company. So it's just that instead of it being titled in an individual's name, it's titled in the name of a trust. Okay. As trustee, what I do is I'm responsible for the trust. I'm responsible for dealing with Schwab and deciding what to invest in. And I'm responsible for deciding when I'm going to distribute money to Brian. So if Brian calls me up and says, "Oh, I need money for a house or I need money for a car," in my judgment, I can decide when to make distributions to Brian. Okay. There are no secret trusts. Mom can't create a trust in her will for her son Brian and say, "Oh, Todd, you're the trustee, but I don't want Brian to know about it." Or Brian doesn't know what the terms are. Okay. Every beneficiary, an adult beneficiary, I'm required as the trustee to let Brian know there is a trust, what the terms of the trust, when I'm supposed to make distributions to him, and what my authority is. Okay, I have to give him an accounting every year that says this is what the trust owned, these were the expenses of the trust, this is the trust paid these income taxes, and this is what's left at the end of the year. So as the trustee, I'm responsible for managing it and for providing Brian with information about the trust so he knows that I am using it for his benefit, that I'm not taking the money and using it for my benefit or somebody else's benefit. Okay. So in this case, mom died and she left $500,000 to Adam and she left $500,000 to Brian's trust. 10 years goes by, and from Brian's trust, he used some of the money, and I invested the money for him. And after 10 years, it's worth $800,000 in the trust account, and Adam's money's worth $800,000. Well, they went to a family wedding. A cousin got married, and Adam and Brian went to this wedding, and there was a bachelor party. And the Smith twins were known for being partiers. Well, it got out of control and they got into trouble at the bachelor party. And so much so that when their wives found out what happened, they divorced them. Well, Adam's $500,000, when he got it, he deposited into a joint account with his wife. And now, when they got divorced, half of that was marital property, and his wife ended up with half of the property. So Adam now only has $400,000. On the other hand, Brian's money was in trust. And when he got divorced, none of that property is marital property and it's all protected. So Brian's entire $800,000 remained in his trust for his benefit. His spouse did not get any of that money. All right, another 5 years goes by and money's invested, and now Adam's now went up from $400,000. It's now worth $700,000. Brian's trust went from $800,000 to $1,000,001. And Adam is a real estate developer, and he got into a bad business deal and he got sued. And there was a judgment against Adam for $800,000. Well, as a result, the person who sued him got all of Adam's money because it wasn't protected. It was in his individual name, and he got sued, and all of that money had to go to pay the plaintiff in that suit. Brian was in a fatal car accident that he caused. It was accidental, but he caused it, and he was sued for $2 million. And at the time, his trust was worth $1,000,001. The trust funds were completely protected. Even though he got sued and there was a judgment for him, against him, because the assets were in a trust, they were protected. So the whole $1,000,001 stays in there, and it will continue in trust for Brian and Brian's descendants. Okay. All of those things would be true even if Brian was the trustee of his trust, not me, a third party. Brian could be the trustee and have control of his own trust, meaning he could write checks to himself and his descendants, and we'd still get those protections. Okay. Most of my clients use, instead of leaving their money outright to their children, they leave it in trust for their children for these protections: divorce protection and creditor protection. Okay, those are the, when you hear about trusts, that's how they work, and those are the reasons. All right, do we have any questions? We could probably finish it up with that.
We have quite a few questions, so if you're
Okay.
prepared, if a house is in a revocable trust, is it shielded then from creditors?
Okay, so we didn't talk about revocable trust. Maybe that's for the next time. But a revocable trust is not like Brian's trust. It is completely different than Brian's trust. Okay? A revocable trust is something, let's say I would create a revocable trust for myself. It's my money that I put in a revocable trust for my benefit. So I'm the grantor. Okay, I'm the person that puts money in, or in this case, my house. I am the beneficiary because I can live in the house and the money's for me, or in the house. And I'm the trustee and I have control over buying and selling the house. That offers zero creditor protection. If I have a revocable trust that I create for me with my money and I'm the beneficiary, any of my creditors could get to the assets in my revocable trust. In Brian's the trust, that was different. It was mom's money that was put in trust for Brian's benefit. Those are irrevocable trusts. Those are protected. But there's no such thing, at least in Maryland, where I can put my own money in a trust, or a house in a trust that I can live in, that I can have access to, that offers creditor protection. They don't exist.
Okay. Do you need to use an attorney to make a trust?
You don't need to use an attorney to create a trust, but I mean, it would be very difficult. So there is LegalZoom, okay, or you can go online, and I'm sure they have forums. But the problem is, like, okay, my plumber. Do I need a plumber to fix my dishwasher? No, I could go online and look at YouTube and buy tools, but I guarantee you that it would not be fixed. So it's like anything. It's, you have to choose how you want to spend your money.
Right. Okay. Makes a lot of sense. We have another question. I'm married, but my mother and I are on the mortgage of our home for financial reasons. Should I add my husband to the deed?
Well, she's married. Whose home is it? Is it her home?
It sounds like her and her mother's.
Right. So that it depends, because I don't know what the deal is. Maybe the deal is, if I don't know how much maybe mom put in a down payment, and maybe if something happens to the daughter, maybe mom wants to get some of her money back. Well, depending on who's on the deed, maybe mom wouldn't automatically get her money back. So the answer is, it depends. You got to sort of look at the situation and see what makes the most sense.
Sure. Another question, if I die and I have credit card debt, are my beneficiaries responsible for those?
No, they're not. Nobody is. When you die, your debt dies too.
All right. Who manages a trust account in the case that something happens to the designated trustee?
Well, actually, let me go back. I'm going to retract that. Yes, but your beneficiaries aren't responsible, but your estate is responsible. So indirectly. So in most states, and in Maryland, for example, let's say I die and I have there's a mortgage on my home, or I have credit card debt. Creditors have 6 months to file a claim against my estate. So if they file a claim with the probate court against my estate, saying that there was this debt, and they show evidence of the debt, then my beneficiaries are not responsible, but my estate is. So now, if my estate, suppose my estate's only worth $100,000 and I have debt of $1 million, my creditors are out of luck. My my beneficiaries don't have to dip in and pay that debt. But to the extent my estate has assets, when I die, those assets will be used to satisfy any debt.
Okay. Um, okay. I was asking who manages the trust account in the event that something happens to the trustee?
Yeah. So most trust, most trust agreements or wills that create trust have provisions for they designate successors. So somebody will say, all right, I'll name my brother as the trustee, but if something happens to my brother, it'll be my other brother. Or there are provisions that say if brother doesn't designate if I haven't designated, I'm the creator of it, a successor to my brother will be able to pick his successor. So there are provisions for appointment of successors.
Okay. We have some questions about, I guess, just in general, what is the difference between the revocable trust and the irrevocable trust? And
Right.
how often do they need to be updated?
Yeah. So again, the main difference is, so the irrevocable trust is when somebody takes their money. So my mother takes her money and puts it in a trust for somebody else. And in this case, she put it in the trust upon her death. That is an irrevocable trust, and it's irrevocable because my mother is dead and she can't revoke the terms of it. But in that case, since it's her money for my benefit, or in our case, in the example for Brian's benefit, those trusts offer creditor protection and divorce protection, all that. A revocable trust is when usually I take my money and put it in trust for my benefit. Okay. And the main reason for that is to not, I can't avoid creditors, and it's not divorce protection. If I get divorced, whatever's in my revocable trust may be marital property and treated the same as if it was in my name. Okay. But the main reason for a revocable trust is it avoids the probate process that we talked about earlier. So that's the reason why. How often do you update them? You should, I recommend that if circumstances change in your family, you have kids or you get married or your finances change, that's a good time to update your wills or revocable trusts or other estate planning documents. But on general, every 3 to 5 years, not a bad idea to look at them.
Perfect. And we have some questions about the cost for will and estate planning. Are you able to give a ballpark figure? And we also have someone curious to know if you are licensed in DC.
If what?
If you're licensed in DC.
Yeah, so I'm licensed. Yeah, I'm licensed in Maryland and DC. I'm not licensed in Virginia, but my partners are, and so we all, we can do Virginia documents. So we have clients in the DC, Maryland, Virginia area. Cost it. So this is my answer to that. How much does a car cost? It depends. Is it a used car or is it a Ferrari? It really does depend on how much time is involved. So, for example, I would say generally a few $1,000s. It's not generally, when I do estate plans with trusts that are there to protect the assets for kids that are built in, and powers of attorney, they're usually in the few thousand, not the few $100 range to give you. But basically, I would meet with clients. So if you're interested, and most lawyers do this, I meet with clients on Zoom now for usually about an hour. I don't charge for a meeting. At the end of the hour, we go over everything. I give an estimate, and if you want to go forward, that's fine, and if you don't, that's also fine. But that's how I do it, and I think a lot of other lawyers do it the same way.
I'm sure that is the way of the world these days.
Yep.
We have a couple of other more specific questions, and if it's all right, I'll forward those to you directly.
Sure, that'd be great.
This presentation, we're at 2:02, so I want to be cognizant of everyone's time and, of course, of Todd's time as well. We want to thank you for explaining the how and why of estate and trust planning. If anyone would like to revisit or rewatch this webinar, you can join us on our website at beconet.com/flourish. It'll be posted along with the presentation. You can also find our calendar of upcoming events there to keep up with what is working on in the future. If you have any ideas or suggestions for webinars and speakers, please, of course, let us know. We'd love to hear your feedback. And again, just want to thank you all for attending today. And thank you, Todd, for helping walk us through all of it.
Thank you very much. And if people have questions, you can give out my website email and they can ask them. I'd be happy to answer any questions.
Wonderful. Thank you so much, everyone. Have a great day.
Thank you. All right. Thanks a lot.